I think I get the concept you're driving at, and work for hire is maybe a term that isn't familiar to everybody around the world. Its basis is in the US Copyright Act, and it's intended to imply a particular relationship between the parties. And it means that instead of, as you were driving at, Sangeeta, something that I create and then decide subsequently to transfer over to you, the gist of the nature of the relationship is that from the get-go, you have commissioned me to do something that you inherently own. I'm not transferring something to you. You're basically utilizing me to do something that will automatically be yours. And again, that's a kind of a difficult concept for some people around the world to understand because it's not recognized. By virtue of that term of art and that special relationship, there are resulting legal implications under US law that have to do with the nature and use and the exploitation of the right. So that is a very good term to flag. Work for hire. Sometimes the copyright laws in the countries don't use those three words, but they basically define it as such. But that is a specific term of art, and it does have specific legal implications, primarily for the entertainment industry.
How would that apply to Southeast Asia, where a lot of our PitchMark's members?
Well, again, every country has its own law. So the law in the Philippines doesn't apply in Thailand and vice versa. So in the Copyright Act, there will typically be provisions that go to these kind of relationships, and you'd find them in there. That's not so much, and again, that will affect any contracts that come up, but that's a function of copyright law. That's a function of the IP law itself.
But in general, can we agree that if someone is commissioning a creative person, whatever they may be doing, someone who is an innovator, someone who has come up with an original idea, is that there is no transfer right of IP? Do I understand that right?
No, what I'm saying is where you have this notion of a commissioned relationship or a work for hire, no, it isn't that one party transfers the right to the other. It's thought of in laws that it's automatically as though the person commissioning the work were the one creating it. I'm trying to figure out a way to illustrate the concept in a way that can be more easily understood, but it's as though you did it yourself without my involvement, versus me doing it and then me meeting you in a bar and saying, hey, would you like this piece of IP I've got? I can sell it to you and it could become yours tomorrow. The concept is it was yours from the get-go.
So an advertising agency which engages a freelance designer to create an ad, for example, the advertising agency owned the IP in the first place. I mean,
that's a really good,
the creator in the first place.
That's a great example, and that's a good example of where it would typically arise. I can't give you an answer that's yes or no in every country around the world that fits all situations, but that's a great illustration of when this type of thing would arise. The other kind of general area where this comes up is, in an employment relationship. Let's say I publish magazines and I need you to write copy for it. And that's just what I'm going to do. I'm going to pay you a salary. You're going to come in every day and you're going to sit at your desk and you're going to write whatever I tell you to write. The nature of that relationship is such that all of your output related to the work I'm paying you to do is mine. It's not yours. So again, it can be either a function of employment.
Even as a freelance writer?
No, I'm trying to distinguish the two relationships. I'm saying on the one hand, you might just be my salaried employee, in which case all of your IP output is mine because I've employed you. The other nature is that you're a freelancer. We agree voluntarily to have a certain type of relationship, but in the context of that relationship, everything you do is going to be owned by me. And that's fully enforceable.
Gotcha.
Nothing inherently against public policy or inherently wrong with that.
We also talked about contracts as a function of the amount of clout and leverage, the sort of the power relationship between the two parties. Could you elaborate a bit more on that?
Yeah. Again, it's probably not specific to the IP or the entertainment industries, but it comes up most frequently. And the notion is that, yes, in theory, a contract is a voluntary agreement between two parties. In practice, the reality is that if you're an innovator and you're negotiating with, say, Microsoft, because you've come up with an idea that they like, the nature of the relationships in these industries is such that there isn't often a lot of clout, or the question becomes who has the clout in the relationship. To use another example, Bruce Springsteen can decide when he creates music which record label he'll allow to distribute it and upon which terms. The rest of the world is basically presented with a recording agreement and told essentially to sign it or else. That's not to say they won't negotiate everything, but what the point to try to get across is that parties shouldn't think that in the entertainment industry or the IP industry that it's necessarily always a free and fair fight on equal grounds. Typically, the negotiating clout and the leverage is going to be on the side of these giants that the people listening today are likely to be dealing with.
Thank you, Frank. Also about contract. I mean, I remember when a lawyer once told me contracts are really only necessary when you have a problem. Oh, that's when they sort of kick in, when there's a problem at the end of the day. I'd like to invite Mark into the conversation as well. Thanks for joining us, Mark. Perhaps you'd like to take over. I've just been discussing the first couple of points in what we intended to do. We talked about the nature of IP and contract rights, and we talked a little bit about work for hire and employment, and now we're talking about remedies for breaches between parties.
Thanks, Sangeeta, and hi, Frank. Hi, everybody. And thank you for the invitation to join you as well, Frank. Please carry on. Sangeeta's question was a very good one.
Yeah, we were really just talking about leverage and clout, and I was saying that while on the one hand, in concept, a contract is a freely enforceable voluntary agreement between the parties. In practice, the reality is that one side is typically going to have more leverage and more power than the other. And the circles that we're talking about this afternoon, if you're negotiating with a Microsoft or an Apple or BMG Music, the likelihood is that they're the ones that are going to have the leverage and the clout. And though in theory, you might go into your contractual negotiation thinking, I can get anything they can agree to. The reality is they're not going to budge too much.
Yeah, unfortunate, but that's precisely where the PitchMark comes in order to provide a little bit of clout. By the way, we're about halfway through the webinar, so if you have questions or comments, Jesse, Phoebe, any of you on the call, please feel free to drop them in, raise hand here in Zoom, or drop a question into the chat function on Zoom. And we'd be happy to take your question as well. Frank, you're happy to take questions for another half an hour or so?
As best I can. We really, Sangeeta had just started asking them, so we really haven't covered very much.
Good.
And
okay.
I don't know what you'd like to do, Mark. Whether you want me to just talk in the middle or
no, actually, well, I've got tons of additional questions. Besides, as I said, for those of you joining us here on the call, please feel free to jump in. I do have a couple of additional points to note, and one is this one here from Menti. You can see that at this stage, only 3 of you have voted on this question. I've had clients and prospects steal my ideas in the past. To be frank, that is actually something that most people say they have had happen. And right now, one of the things that we're looking for is for you to tell us about what those stories are. Everybody seems to have a story to tell. Virtually everybody in the creative industries has had an issue along these lines. So once again, please feel free to share yours, maybe without client names just at this time. Yeah, right. So 3 and 4 of you seem to have had this issue. And also we're asking about this question here, Frank, which at some point in the next 20 minutes, could you address this question?
Yeah, we touched on this a little bit. A contract doesn't have to be on a particular size or color piece of paper with the magic word contract in it. A contract is simply an enforceable agreement. It doesn't even have to necessarily be in writing. So the answer is yes, an exchange of email correspondence could constitute the basis of an enforceable agreement. Having said that, this isn't typically the way the creative and IP industries work, by means of exchange of email correspondence.
Indeed. Yet, how many times have we seen reports of, where people have said, well, I sent an email and therefore that counts as a contract. Can you at least give us a...
You'd have to have an offer and an acceptance. The basic elements of a contract is nothing more than an agreement that's enforceable. Before you joined on, I said to Sangeeta, I could make a contract with her to shoot her husband, but she wouldn't be able to take me into a court to enforce it.
Right.
So on the one hand, to have a contract, which is nothing more than an enforceable agreement, you have to have kind of 4 general concepts. There has to be consent. We have to voluntarily enter the agreement. You can't put a gun to my head and say, sign this or else. You can't hold threaten to burn my house down unless I count the contract. I have to do it voluntarily.
Right.
There has to be capacity. I have to be of a sufficient age often to have an agreement, enforceable agreement. You can't get a 5-year-old to sign a contract and hold it against him in court or her. You can't sign away your life when you're drunk. There has to be there has to be something that's called capacity between the parties. They have to be able to voluntarily enter that agreement. There has to be something called consideration, and that's what our friend Mr. Trump would call the quid pro quo, an exchange, a benefit for something. A promise from one side to the other isn't in and of itself enforceable. It has to be a promise for some sort of performance, or maybe a payment, or for a forbearance. And then the last concept is the first one. In fact, it has to be legal activity. I can make a contract with you to sell you cocaine, but you can't get a contract. You can't haul me in front of a court and enforce it.
Right. Okay. So in other words, as long as those elements that you've mentioned are part of the email is the contract. Is that correct?
Yes, and assuming there was an offer and an acceptance, assuming a court could reasonably construe that one party was offering up something and the other party said yes. I can't send you a one-sided email and then your silence is deemed to have accepted it.
So as soon as you then hit reply on that email, does it then count as an acceptance?
We're going to come into a situation where you're going to ask me questions and I'm not going to tell you yes, no. The answer is always going to be, it depends.
Oh, no.
Be a wise guy. Well, it's just true, Mark. That's just, you can't possibly generalize. Yes, an exchange of email equals a contract. It just isn't that way.
So the fact that it's a 50-50 rating at the moment is probably about right. It could be. Maybe it depends should have been the third choice.
Yeah, I think, again, the concept is that contracts don't necessarily need to be on parchment paper with the word contract.
Right. Okay, cool. Phoebe, thank you for asking this question, and feel free to unmute if you'd like to join the conversation. Frank, Phoebe is asking, most contracts are complex to read and understand with templates and formats. Is there a way to shorten it using layman's terms and still make it valid?
Yeah, there would be, but again, it boils down to clout and leverage. There's a good and valid reason why, a simple definition takes 1 million words to define. And that typically gets back to the point before about when the stuff hits the fan, you want to have that definition. But I guess what I'm trying to drive at, it isn't anybody's advantage to have layman's terms. It's great in a perfect world, but why would a book publishing company want to give you a simple, easy to understand contract instead of giving you their form contract that's completely sided to their favorite perspective? It just, again, parties have to be willing to put something in layman's terms. There is a huge movement, though, afoot to, why does the legal world tangle itself up like this? The answer is it just does.
Well, and there's also plain English contracts, right? So some jurisdictions, actually, some countries have laws that force you to have a plain English contract. Let's say you're getting into an insurance policy because so many people buy insurance without understanding the product. You're saying,
yeah, that's an example of a consumer protection provision. And then again, you don't want that. Kind of gets back into the capacity point of view. You can't have somebody sign something that they don't understand. And the point could be, what, this guy just gave me a contract. I didn't know what it was. I asked him questions he wouldn't answer. Mm-hmm. If your perspective is to not have that agreement enforced, and you've been presented with something that you've signed and it's complex, you're going to try to play as dumb as you can. I don't know. Sorry, you never talked about it with me. I did ask him. He wouldn't explain it. I don't know what I said, Your Honor. Right. They're going to try to do the other thing. No, we signed it. It was all put there for a reason. It was straightforward. He had every opportunity to negotiate it with me. He didn't.
Mm-hmm. So that battle continues. Phoebe, maybe I could offer some additional thoughts on this point, because I think we all have a lot of sympathy for your case. We would all like this to be the case. But as somebody who's drafted the contracts in the past, what you will know is that you try to make it layman terms. You try to explain it and say, it's so simple. It's this, and followed by this. But then when you look at each individual point, you start to think, well, how do I make this a bit more watertight? Am I using the right words? What happens if they now say this? Oh, and I forgot to add this in. And so often the attempt to start with a layman term contract ends up in the same complexity that you would have had to begin with, because you end up building in more points, you end up trying to define more points just in case they challenge you on this or that, just in case they start to pick holes in this or that. So that's not to say that we must have complex contracts, but we probably must have better conversations with the client. So that a lot of those, what if they say this, what if they poke holes in that, that those terms, that conversation is had with the client. And that agreement comes out in conversation where everybody's on the same page, rather than kind of sticking it into the fine print and then upsetting everybody. And that's really what the PitchMark certificate aims to do. You know, clearly we want people to PitchMark their work, present that to the client, and for the client to take pause before they rip off the ideas. But one other benefit might well be that the client asks you about it. Hey, I saw your PitchMark certificate. What is this all about? Why are you, what is your concern? And so that hopefully in the course of the ensuing conversation, you will be able to deal with some of the points that might otherwise be too complex in the contract. Frank, Phoebe is also asked, you're very welcome, Phoebe. Phoebe's also asked, is non-notarized contracts, are they still valid?
I'm sorry, I missed the word.
Sure, are non-notarized contracts still?
Yeah. Yes, they are. The majority of agreements I sign are not, in my every day-to-day life, are not notarized.
Okay, is there any benefit, just to extend Phoebe's questions, is there any benefit from getting it notarized?
The function of a notary is simply to attest that the person that signed it really was that person. It isn't intended to imply that the person that signed it had a knowledge or understanding of what they were doing. That's not the function of a notary. They're not to say, do you realize that you're signing a mortgage agreement? It's simply, who are you? Are you really Joe Smith? Okay, prove it. Sign Joe Smith. Boom, Joe Smith came before me this day and signed it.
Right. Okay. Good, Phoebe. I hope that's answered your initial question. But let me build on that a little bit more, Frank, because the whole question of non-notarized contracts, you said earlier on, if you're not in a strong bargaining position, you know, if you're creating a creative campaign for some major multinational, Coca-Cola, Amazon, take your pick, you know, you're in a weak bargaining position. Does getting it notarized heighten the value? Does it show that you're punching above your weight? Does it in any way bolster your position that you've gone that far?
Again, I don't, that really isn't the function of what notary publics do. So if I was on the other side of that agreement and I saw it coming with a notarized signature, no, it wouldn't sway my opinion one way or the other.
Okay.
Unless I told you for whatever reason, this document, this agreement we're going to sign, I'm going to have to present it then to a bank because we're going to have to go get financing, and the bank wants to see it notarized. That might be a reason why. You know, if there's a reason, decent reason valid for it, you know, that's when you employ the services of a notary. But you don't use it as a means to get out of it. Oh, it's not valid because I didn't notarize it, so I can walk away from it.
Yes. Well, and that's actually exactly also where the PitchMark certificate comes in, because the whole point is to spark a conversation without necessarily going to the lawyers for it. You know, clearly the global legal network of PitchMark is there to help, but not to overcomplicate matters,
right,
or for some sort of formality, you know, formal stamping of the agreement. Cool. So if you have additional questions, please feel free to drop them into chat. I've still got a million to go, but if you're with us on this call, feel free to drop them into the Zoom chat or on Mentimeter, drop your questions in there. Frank, a few other points about contracts and a particular contract negotiation. You know, one of the other things that if you've worked with contracts for a long time, that you'll probably realize is that the contract is really the end of the process and not the beginning. So can you talk us a little bit more through that as to what actually has to happen before you get to a contract stage, and what happens if there is something that wasn't discussed, which then somehow miraculously pops up, you know, in some sort of subclause way down the list of a contract?
Yeah, that's a good question. I think you're right. A contract is intended to reflect the conclusion of discussions and negotiations in a voluntary agreement, or reflect the conclusion of the relationship the parties are getting ready to sign. or enter into. So the best thing you can do is use the contract to advise and discuss. Make sure the clients, both parties of the clients, understand what's being discussed and put forward. That's probably the first element of what you can do.
And then what happens if you do then find a clause along the lines of, maybe an IP clause, all the background and foreground IP belongs to us.
Yeah, there's typically a process of communication between the parties, and it's understood. I'll send you a draft agreement, and then we'll negotiate it. So I'm going to send you an agreement, Mark. Take a look at it and let me know any concerns you might have. And while we're, again, it's not the case that I'm going to try to say, well, I sent it to you and you didn't get back to me. So we want to have a relationship that's going to be enforceable. It's not in my interest to try to bamboozle you. So there will be a process by which you'll say, I think this is unreasonable. I'd like to change that. Could I have an extra month? Could you maybe give me an increase in points? And I'll say yes, no, maybe. And then at the end of that process, you can decide whether you want to enter this contract or not. I mean, to your point, it is often at the end of the process a take it or leave it situation. And from a client's point of view, the best they can do is enter that agreement relationship or not, apprised of all the necessary knowledge. You don't want to have a situation where you sign something and say, oh, I never realized it because I never bothered reading it, or I didn't really understand what it meant, so I never asked anybody to explain it to me, something like that.
Okay, you said that it's not in your interest as the client to bamboozle the supplier.
It's not in anybody's interest. No, I'm saying if I'm a record, it's not in anybody's interest to bamboozle the other side, because if you want a situation where you want that agreement enforced, you don't want to present yourself in court as somebody who just swindled the other guy. I gave him some 30-page piece of 30-page single-spaced agreement. I told him he had 2 minutes to sign it. Take it or leave it. It's not going to make me look very sympathetic. At the end of the day, Mark, law is a function, contracts are a function of reasonability. You can't just say, well, it's on paper and you signed it, so tough luck. You now have to cut your leg off because you didn't give Mark the article on time. And it says in the contract that if you don't do that, you cut your left leg off. It's not going to be enforced. It's just not reasonable. Okay,
let me challenge you a little bit on that, because the number of times, I've received contracts from large multinationals who do throw their weight around. They'll say something like, well, our lawyers will take 6 weeks to send you the contract. Of course, the contract arrives after 3 days because they were just trying to show you how muscular they are, that they have in-house counsel. And then, the contract is single-spaced, 20 pages. Look at most government contracts, in fact, to see that. And you kind of get the impression that they deliberately make it complicated, because if it is only 5 pages, you might actually read it. And so, again, hence my point that if a contract arrives in your inbox and it is 30 pages, and like Phoebe, like so many people, you look at that and think, I don't understand any of this. What should be the next step?
I guess I'd answer that question by asking another one. Phoebe's probably done it 5 times today without even noticing it. Does Phoebe have a Netflix account? Did she check box on the terms and conditions? Did she read it? And I'm not picking on my friend Phoebe. I'm just saying we all do this every single day. You buy some software and insert it into your computer. You are making a contractual agreement with Microsoft to do and not do certain things. And they'll know if you violate it because they're just that smart. They figured it out that way. But, terms and conditions, every single day of our life, we're doing this without reading it. So what's our recourse? I don't know. Stop, read it, ask a question, make a decision. They might say, yeah, we're Netflix. I'm not going to change a word. You want my service? Click the box. You want to waste my time? I'm going to hang up.
Yes. Although the way Netflix is going, they might actually care.
Yeah, they might actually need you. I'll pay you to take it. Yeah.
Still, is it then enforceable when the contract is yay long and you've got to scroll through the end user license agreement?
Depends what it says, Mark. Depends what it says. Depends what the situation is. Depends what. I mean, the majority of times in life, 98% of the time, we do these things and nothing ever comes about of it. I know we're trying to use a situation of a specific situation where I gave you something and it got ripped off, but I'm just trying to illustrate that contracts are all around us every hour of our lives, and we barely even stop to think about it.
Yes. Okay, so let's say then that you do have a contract, you've received it, it's complex. Do you in any way lessen your bargaining position by asking the person you've done the deal with, or you're prospectively doing the deal with, to then say, hey, there are a few points in the contract that I'm not fully sure about. Do you mind walking through it with me?
I never got, when I was negotiating contracts for a living, I never got offended or bothered if anybody asked me to do that. I mean, again, you really want to hope that you want to be able to say to your boss, yeah, he knew what he was doing. So it's a good and reasonable question that will always be entertained. It may be, though, that the answer is, but we just can't change it.
Yes.
These are all reasonable points. I remember, I'll give you a little war story. One of the very first things, I was in a book publishing company, and I was dealing in an agreement with the William Morris Agency, which is a huge talent powerhouse. And we were negotiating the standard agreement under which their authors would sign our contracts. And I had all these good and valid reasons why I should get certain leverage and certain points on the contract. And they just simply said, no, no, no. And they were kind enough to explain why, but this is the way it goes. Nothing I could have said in terms of why it would have changed their mind. And they were kind enough to explain to me why the world works the way it did and why my request wasn't going to be accepted by them. And they didn't, there wasn't any offense. I wasn't wasting their time by asking, but it past a point, it became evident that, this is just the way the world works.
Okay. Let's say, though, that you do have a situation where you've got questions about the contract, or there are certain clauses that you object to, and the client doesn't even want to talk to you about it. It's a take it or leave it situation. Is that cause for you to say, hang on a minute, this is now no longer about the contract. This is now my concern is that the counterparty doesn't seem to be terribly interested in my point of view, even when it comes to something as simple as reading or explaining the contract. Therefore, I need to be more cautious about doing any deals with them.
That might be the way you conclude. Yeah, you might walk away with that experience. I'm not sure what the question is, though.
Well, that is the question. And again, I have a little war story to tell.
Yeah, I mean, you're right. You'd say, geez, I've been talking to this person for 2 weeks. I feel poorly towards them now. I'm suspicious of them. They evade questions. I'm not sure I want to get into a working relationship with them. Yes. And maybe that's the best thing that ever comes out of it. Maybe you've saved yourself from getting into a bad situation. Yep. Maybe the contract has helped to stir off problems.
Right. This is actually exactly my leading question to my work.
Okay.
When you do have a take it or leave it situation, and no, I'm not going to explain it to you, you do then start to wonder, don't they? What is it that they're trying to obfuscate about? What is it that they're trying to leave unclear? Are they scared of being asked difficult questions that they can't substantiate? And so from that perspective, that's again why the contract should be the end of the process rather than the beginning. Because once you've got an understanding of what the desired outcomes are, if the final product that you're then sent, if you're getting sent the draft and it isn't what you've agreed with, then again, you can spot the gaps. And if they're not willing to explain it, might not want to touch it. Let me ask you specifically, before I take one more question here. And by the way, we've only got 10 minutes to go, so please submit your questions now. Question about IP specifically in contracts. War story for you. Educational institution puts out an RFP, a request for proposal, and in the contract, it then says, you, by accepting the offer, you agree that all of your background and foreground IP is transferred irrevocably without compensation, et cetera, to us. When you read the glossary, it then tells you what background and foreground IP is. Foreground IP is the knowledge that you put into creating a customized proposal for this customer. Background IP, Frank, tell me if I'm wrong, is all of the kind of the knowledge that you've amassed as part of you being in this business for a number of years, correct?
Probably where this is going.
Yeah, and so in other words, this client was expecting people who won the contract to, in essence, hand over their entire company. Because if you're a creative agency, Or, as we saw earlier on Menti, in terms of the types of businesses that you're in project management. You said on Menti earlier, you're a technology designer, you write business ideas, you do copywriting, pitch decks, and so on. The reason why anybody will want to work with you is because of your experience in project management, your experience in design, your experience in copywriting. And if that experience now counts as background IP, and you're in essence handing that over as part of this contract, you're actually saying, please take my company for nothing.
Yeah. And I mean, again, that strikes me as the sort of example that taken to its extreme, it's difficult to think that a court would really enforce it. I wonder if that just might have been an example of an overzealous lawyer drafting up something that fits in every possible contingency. I mean, a lot of times, again, we sign these things and we probably shouldn't, but it just never comes up.
Yes.
But yeah, you're right. And what you just described, that sounds like an extreme situation. And the part that I jumped on is it said without compensation.
Yes.
Maybe I mentioned before the concept of consideration, the quid pro quo. Maybe it's their consideration was, we're considering your idea and that's value enough. But come on. Yeah. It's not going to enforce that.
Well, that's good to know. Well, in any case, I then messaged said educational institution, and I said, the only people who will agree to this contract are those who haven't read it, because if you have, then you'll know that signing over all the IP that you have amassed over the years is not really how you want to do business. In fact, you're out of business. And so they then came back. There is a part 2 about this, and I did make the point to them about the overzealous lawyer. In fact, I wrote to them, this sounds like it's been written by a lawyer who absolutely has no business sense whatsoever. Right. Anyway, so but the story didn't end there. In essence, they then came back, having gone back and forth, and realized that actually this is a contract for photography. And the concern, which of course has come up in Singapore since then, is that when you hire a photographer to take pictures of your, let's say, your wedding or some other corporate event, in the past, photographers have kept the negatives, whereas in essence, the law has now changed and you now, as the client, also own the negatives. And so that was what this contract was drafted for, that not only do you own the prints of the event, but you also own the negatives. But they hadn't adjusted the contract for the particular training concept that was under discussion here.
Rather overbroad than in the context.
Yeah, exactly. And so by, there was simply no opportunity with just 1 day to go before the close of the tender for them to make any changes to the contract. But the bottom line is we walked away. I don't want to be in a situation where somebody then takes your IP, background IP, all of your corporate knowledge and uses it. I realize you might feel that you don't have the choice to walk away. You've got to eat. Right, and you've got to make the money, and you've got to win this client, and so it's up to you to figure out where to draw that line. But at some point, draw that line you must, and be prepared to walk away, especially when the contract does not say what you agreed during your meetings with the client. Frank, any additional thoughts?
Well, just one concept that we didn't get onto, but that's relevant in light of what you just mentioned. There are, under many copyright laws, it's a copyright concept, really, that despite the fact that I might transfer my IP to you, I have an ability to get it back. And again, that's just the concept under law that things should be reasonable. And maybe we entered into a contract at an early part of my career where you had the leverage and I didn't. And it's just against my interest. It's something I did, you get the benefit of for so long. So it's not uncommon for countries to have provisions in their laws that says, despite whatever language we use, whatever we voluntarily agreed, all bets are off after a certain point of time. And either I or my heirs have the right to come to you and recapture the work. Cannot do that in a commission basis, typically, or what in the US is called a work for hire. Because again, the very nature of that magic word relationship is such that it was never contemplated that I'm actually transferring anything to you. It was yours to begin with. I'm you. It's as though you hired me as an extension of you and you created the work. So for these works for hires and commission, it's yours free and clear. But typically when two parties voluntarily, I meet you in a bar and I sell you my movie, many times the laws will have a provision whereby at a certain point in time, I can say, I want another bite of the apple more. And if it's a good property and you're happily exploiting it, you'll gladly do that. And you'll be smart enough to say, you know, Frank, I know you want me to pay you for the entire life of the copyright, which is your lifetime and 50 years after, but I know you can come back in 35 years and try to get it back to me. So let's negotiate reasonably here. I'm not going to give you the 10 million you want. I'm only going to give you the 2 million that I think you deserve.
Okay, so bottom line, have that conversation.
Yeah.
And a lot of this is I guess why PitchMark is all about, you know, sparking conversation. Because if you have a frank, if you excuse the pun, if you have a frank conversation with the prospective client, then there's you know, you can avoid a lot of this. In fact, the lawyers will tell you, you know, you're much better off avoiding conflict to begin with than ever letting it get near the courts. Because once it's there, it's costly, it takes a lot of time, a lot of effort, and in the end, you might not get what you want. One more question here, and then we will head soon towards a wrap. Thank you for this question. If a publisher wants to create an app based on characters you created for a book, but there were no provisions in the original contract for the app, it was just about the book, what recourse do you have? Or do you ask for a new contract? Will it fall under the original contract?
So to make sure I understand, I appreciate I'm talking to you through somebody else, but publisher, there's a character in a published book, and then the publisher decides to build an app around that character.
But the original concept was only covered for the book.
Yeah, you sure? As a former director of contracts for a book publishing company, I absolutely would have tried to acquire the rights to make what are called derivative products out of your literary property. And I absolutely would have tried to get you to sign me the rights to create an app with your characters.
But in other words, you would want to have another conversation with the author. You wouldn't just do so.
It'd be in the contract that I present you. And the transfer of rights, I'd seek to get your publishing rights in the book, and then I'd seek to make a movie out of it. And I'd seek the right to make a tape out of it. And I'd seek the right to make a theme park ride out of it. And I'd seek the right to take any character that might come up and make costumes out of it. And I'll try to acquire as much as I possibly can. And it'll be up to you to read it and ask me whether that's reasonable or not.
But Frank, that's precisely the question, right? So you would actually go back to the author and you would say, hey, you know, I know we only signed for the book, but now we want to create the app, the movie, the t-shirt. You would actually go back to the author, or would you just silently, quietly, in view of the fact that there were no derivative rights in the initial
contract? No. Sorry. The answer is depends, but no. If I wouldn't take it on a presumption that I had it if it wasn't transferred. I'd have you sign something that already transferred it to me, and then I wouldn't bother calling you and telling you I'm doing it. And then when you found out about it and you complain, what the hell are you doing? I saw a costume about my character. It's, well, read your contract. Or I'd say, good news, that contract you signed years ago, we find a design for it. We'd love you to be there at the grand opening and stand up there and hold up the first mass. So look, again, the relationship between the parties, I want you to be happy. I want you to cooperate. I don't want you to feel that you made a bad agreement. But this is business. I'm going to try to acquire as much as I possibly want from the get-go. I don't want you stopping me up. I'm in the business of knowing how to exploit the rights that you've transferred to me. Get out of my way. You go create. And leave it to me to make money. We'll all be happy.
Now, is that just you, Frank, or is that a general assumption that the other party does want you to be happy?
No, I think generally speaking, they do. You know, again, film companies are not in the business of creating problems for people. They want to make movies that are enjoyed and loved by millions of people. Everybody, you know, in a perfect world, you want everybody to be happy. I don't know of anybody in the entertainment industry, the IP industry, that wakes up. Actually, I shouldn't say that, Mark. We're getting into a whole thing. Let's avoid the concept of, say, trolls, IP trolls, and people who are really evil and use IP as a way to make nasty things. I would say for the most part, the general world, yes, everybody wants everybody to be happy. Nobody wants to be perceived as having taken advantage of another side. Everybody wants to have good face and reputation, both on the creative side and on the business side.
So if you get a contract, let's say you've signed over your rights or you've licensed your work for a particular purpose, and it does not say includes derivative rights, should you then actually proactively say to the publisher, hey, I noticed that you're only licensing my work for the book. So just to confirm, you're not going to build an app. You're not going to write them.
No harm in that. No harm in letting the other side know that you're aware of what you've signed, and, you know. But again, it's difficult to imagine a situation, you know, again, unless it's that J.K. Rowling, she can probably tell the book publishers whatever she wants them to do. But if I write a book, you know, I'm not going to be able to. I'm probably not going to be able to retain my movie rights.
Oh, Frank, I think you're selling yourself too short.
Ah, thank you. No, that's just because I used to negotiate with myself.
Right.
I would never allow myself to keep film rights.
Thank you for negotiating with us today, Frank
Oh,
Rittman,
my pleasure.
legal
Thanks
advisor.
for the opportunity to join everybody, and thanks for the great questions.
Yeah, my pleasure. And thank you for watching. Please, once again, remember to sign up at pitchmark.net. If you have any questions or comments, hit the live chat button in the bottom right-hand corner of the site. And of course, we're very happy to continue the conversation. Look out next month on the 8th of September, we have our next webcast webinar. Frank, what are we going to be talking about?
I believe we're getting into photography in the law. So some of those specific photographer questions that in your example that you used.
Thanks everybody for joining us, and see you next time.